Hello everyone. Welcome back to our channel, Quickora Global. We hope you're doing great. In this video, we're going to talk about major UK immigration update November 2025. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. The UK government has unveiled a sweeping reform to its immigration framework, specifically targeting long-term residency and indefinite leave to remain eligibility. This major policy shift will profoundly impact those aspiring to settle permanently in the United Kingdom. The proposal, which marks one of the most significant changes in recent years, seeks to strengthen residency integrity and ensure applicants have deeper social and economic ties to the country. Increase in ILR residency requirement. Under the new proposal, the continuous residence period required for ILR eligibility will double from 5 years to 10 years. This adjustment aims to ensure that only individuals with a genuine commitment to the UK's long-term growth can obtain permanent status. The reform will be implemented gradually between 2026 and 2030, giving migrants time to adapt. Those pursuing eventual British citizenship must also account for this extended stay, as it will affect the overall timeline toward naturalization. New eligibility tests and compliance checks. In addition to the longer residency period, the Home Office will introduce stricter eligibility tests. Applicants must now meet enhanced standards of personal responsibility and transparency. These include maintaining a clean criminal record with no convictions or legal infractions, demonstrating financial integrity with no record of bankruptcy or unpaid debts, avoiding misuse of public funds or welfare fraud. These reforms aim to reinforce public trust and ensure that ILR holders embody strong moral and economic accountability. Community contribution and employment proof. Future ILR applicants will be required to prove active participation in the UK's economy and society. This video maintaining consistent employment or self-employment, paying regular national insurance contributions, and engaging in voluntary or community service. The objective is to highlight not only professional stability, but also a sense of social responsibility and cultural integration within local communities. Enhanced English language and life in the UK test. Language proficiency and cultural understanding remain vital. The revised framework will introduce higher-level English proficiency standards alongside the mandatory life in the UK test. This ensures applicants are well-versed in British values, history, and civic life, and can communicate effectively in daily and professional environments. Preparing for the transition. These forthcoming adjustments demand early preparation and proactive compliance. Migrants should maintain a spotless legal record, demonstrate ongoing employment, contribute positively to their communities, and stay updated with policy rollouts. By aligning early with these enhanced ILR requirements, individuals can secure their future in the UK with confidence and stability. UK's biggest immigration reform. UK skilled worker. UK's biggest immigration reform kicks in tomorrow. Here's how it will affect you. The United Kingdom will enforce a sweeping reform of its immigration framework from November 11th, under the Statement of Changes in Immigration Rules presented to Parliament on October 14th. The Home Office has introduced wide-ranging amendments affecting nearly all visa categories, replacing the existing refusal framework and restructuring routes for work, study, family, and humanitarian applicants. Unified Rulebook under Part Suitability. The centerpiece of the reform is the replacement of Part 9, Grounds for Refusal, with a new framework titled Part Suitability. This change applies across most visa routes, including work, study, family, and visit categories. It establishes a single standard for refusals, cancellations, and revocations of permission to enter or stay in the UK. The Home Office said that decisions will now be classified as mandatory or discretionary. A refusal will be mandatory when an applicant has a serious criminal conviction, a deportation order, or has used deception in an application. Discretionary refusals will apply in cases involving minor offenses, unpaid NHS debts, or failure to attend interviews or provide biometrics. Applicants may also face cancellation of permission if their sponsor withdraws, they stop working or studying, or their circumstances materially change after entry. Those who lose permission through their sponsors will also see dependents' permissions revoked. Standardization of overstaying and re-entry rules. The updated rules codify clear time-based bans for previous breaches of immigration law. Individuals leaving voluntarily at their own expense will face a 1-year ban. Those departing at public expense within 6 months will be barred for 2 years. Those removed at public expense or who use deception in their applications will face a 10-year exclusion. Overstaying will be disregarded where applicants apply within 14 days of expiry and provide a reasonable explanation. The Home Office will also continue to overlook overstaying that occurred during pandemic assurance periods and for certain Hong Kong BNO visa holders. Updated definitions and introductory provisions. The introductory section of the immigration rules has been revised for clarity. Permission to stay will now replace leave to remain. A new global universities list, compiled annually using the Times Higher Education, QS, and academic ranking of world university systems, will determine qualifying institutions under graduate and talent schemes. For the child-student route, new definitions have been inserted for guardianship organization and nominated guardian, formalizing who can supervise minors studying in the UK. Only British citizens or settled persons may act as long-term carers. Route-specific amendments. Student and child-student routes. All applicants will now be subject to Part Suitability. Updated financial requirements raise living cost thresholds to £1,529 per month in London and £1,171 outside London. Guardianship and living arrangements must involve a British or settled adult. Family and private life routes. Applications under family and private life categories will be assessed against Part Suitability. Applicants found to have used deception, entered sham marriages, or owed NHS or litigation debts will need to complete 10 years of lawful residence before qualifying for settlement. Existing safeguards for victims of domestic abuse and bereaved partners remain unchanged. Work and business routes. Skilled worker, scale-up, global business mobility, and innovator founder routes will follow the new suitability standard. Sponsors must maintain compliance or risk cancellation of permissions for workers. The English language level for skilled worker and scale-up applicants rises from B1 to B2, with transitional arrangements for those already holding permission. The high-potential individual route will be capped at 8,000 applications annually from November 1st each year. The rule also recognizes research as a valid purpose of stay under the category. Statelessness and humanitarian routes. The previous Part 14 has been replaced by a full rewrite titled Appendix Statelessness. It allows 5-year permission to stay, access to work and public funds, and settlement after 5 years. Partners and children who formed part of the family unit before status was granted can apply under this appendix. Humanitarian routes such as AROP and the Ukraine scheme are also aligned with specific paragraphs of Part Suitability. The Home Secretary will conduct a formal review of all relevant immigration rules every 5 years to determine whether the rules meet their intended objectives and if less restrictive measures could achieve the same outcome. The findings must be published at the end of each review period. Applications made before November 11, 2025, will continue to be decided under the current rules. From that date, new applications will be subject to Part Suitability and the revised appendices. Minor technical amendments, including permission for certain students to start self-employment under the Innovator Founder route, will follow on November 25, 2025. The government described the package as a consolidation measure aimed at modernizing and simplifying the decision-making process across all immigration categories. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.